Buckle up because this courtroom scene is completely wild. A defendant walked in carrying a concealed firearm, and instead of staying calm or silent, he kept talking non-stop, turning everything into total chaos. Every time he opened his mouth, he made things worse until he ended up completely ruining his own plea deal right in front of the judge, and you honestly would not believe how fast it all fell apart.
Yeah, we go, holla.
Lamont, you like that?
Yes, I like that one.
Throw up both your hands. Okay.
Throw up both your hands.
Yeah.
Oh yeah, throw up both your hands.
Oh, okay. Okay. You stay muted, Mr. Bailey. Please.
Yeah, y'all
don't
can come up in the courtroom, but I can't.
Beg your pardon?
Nothing.
Oh, I didn't think so. Okay.
Oh, I ain't think so. I'm just gonna repeat what you said. You said throw up both your hands.
No, I didn't say that, sir. That was not me.
I was about to lift up both my hands. That's all.
All right.
I was about to.
There's John Holler,
Okay,
the
there's
attorney. Is the attorney here?
Yeah, Mr. Holler, your client, and okay.
I don't see him.
What kind of? You must have
You sound like a man. Hey, you sound like a man there.
Oh, there he is. Yeah, John, we're back.
All right, Mr. Holly, you ready?
I'm ready.
All right, Mr. Bailey, I'm calling your case 24-0556-2701, People versus Marvin Bailey.
Good morning, Your Honor. Cal Nager for the people.
Where's the nitro camera not on?
Oh, yeah,
I don't see him.
Girl, okay.
Hold on, sir.
Yeah.
Mr. Holly, appearance.
John J. Holler on behalf of Mr. Marvin Bailey, who's joined us by the Zoom technology.
All right, Mr. Bailey, I need your name, sir.
Marvin Bailey.
All right, good morning. All right, Mr. Nager, any offers here?
Judge, Mr. Holler emailed me some information yesterday to give me more to look at and read, and I've had email communication with him. Currently, the offer is no reduced plea.
All right, how you want to proceed today, Mr. Holler?
Well, the offer is no reduced plea and 2 years of probation. Isn't that right, Mr. Najjar?
Correct.
Okay.
With other conditions, that's correct.
Okay, with some other conditions to be determined. If we can do a situation where my client can pay in lieu of community service, something like that, we can take a plea today.
So here's what makes this case completely unbelievable. The prosecutor offers the defendant a deal that most people would grab immediately without even blinking: 2 years probation on a felony charge, which in courtroom reality is basically a lifeline, a clean exit, a chance to walk away without jail time. Any rational person would sign it, thank the court, and move on with their life, but not this guy. He somehow convinces himself he is the smartest person in the room, fueled by a couple of YouTube videos and what he thinks is legal expertise. He starts challenging everything in the courtroom, arguing procedure, talking over people, and trying to lecture an actual judge, and with every single sentence he speaks, he digs himself deeper into trouble. What should have been a fast, simple resolution slowly collapses into complete chaos until the entire hearing turns into a total disaster, and by the end it becomes very clear that mixing fake confidence with serious felony charges is a recipe for self.
Cameras off.
I'm here.
All right, you understand what the prosecutor's offer is, sir?
No, I don't.
Mr. Nager.
I don't even see the prosecutor. Who is the prosecutor? His camera's not on.
What does that have to do with it, Judge?
The prosecutor. Okay, the offer that we've discussed is to plead guilty to carrying a concealed weapon without a license to do so, which is a felony. 2 years, a sentence agreement of 2 years of probation. And you will have the opportunity to pay.
Here's the part that really makes you think, why try to act like a courtroom expert when you already have a lawyer whose job is literally to handle all of this? If something is unclear about the plea or the process, the smartest move is to ask your attorney, not start debating the judge yourself, because that is exactly how people lose good deals and create problems out of nowhere in court. The less you try to improvise, the better your chances of walking out with something still on the table.
Hey.
Okay.
Mr. Bailey, watch your mouth, sir.
Man, okay.
Here's what's gonna happen, Mr. Bailey. If you keep it up, I'm gonna bring you into the courtroom and take you into custody and find you in contempt. Settle down, sir.
All right, bro. All right.
That's the judge and not your bro.
All right, sorry about that. Sorry about that, Judge.
All right, go ahead, Mr. Holler.
Okay, thank you, Your Honor. And at the time of sentencing, the court can determine that the that Mr. Bailey would be able to pay a certain sum of money in lieu of community service if he so chose. So it would be like an either or type of thing. So that the court would determine an appropriate amount of community service versus an appropriate amount of additional costs or fines, however we want to characterize that he could pay at his election. He would be on probation for 2 years.
All right. Mr. Bailey, you understand what that offer is, sir?
Yes.
All right, you waive your right. Now you understand you have a right to have a preliminary examination, sir?
Yeah.
You waiving your right to have a preliminary examination today?
Yes, sir.
Anybody threaten you or force you to get you to waive your examination right today?
No, don't nobody threaten me.
All right, court's going to accept the waiver. Mr. Bailey will automatically be bound over. Mr. Holler, as it relates to the arraignment, he's standing mute and waives the formal reading of the information.
I do.
Court's going to enter not guilty plea today.
Hey, can I ask a question?
Nope, that's not how any of this works. You don't just walk into court, say guilty, and expect the judge to approve it like a formality. The court has to hear a clear admission of what you actually did, because a plea deal is not a shortcut that skips the legal process. You still have to acknowledge the conduct on the record, and when defendants start acting like they understand the system better than the judge or try to avoid basic questions, that's usually where everything begins to collapse. And in this case, that lesson is about to hit in the most uncomfortable and embarrassing way possible.
Go ahead, sir.
Can I ask a question?
Go ahead, sir.
After we do this plea, like after I finish my probation and complete everything, like, would I still be able to get my license? Because I like to have my documents intact, in order, and everything.
All right.
I know I was wrong for the case and everything, but like, would I be able to do that?
You have to talk to Mr. Holler about that. He can give you the legal advice.
Okay.
All right, please raise your right hand. You freeze. All right. Do you solemnly swear or affirm the testimony you're about to give today will be the truth?
Yeah.
Yes?
Yes.
Yes.
All right, you can put your hand down. You understand if I accept the plea from you today, sir, you give up or you waive? First of all, you understand that the maximum penalty I can impose if I accept a guilty plea can be up to 5 years in prison?
Yeah.
You understand if I accept the plea from you, sir, you give up or you waive certain constitutional rights?
Yeah.
You understand you waive your right to have a trial by judge or jury?
Yes, sir.
You have your right to remain silent without that silence being used against you?
Understood.
Is that yes?
Yes, sir.
You have your right to be presumed innocent until proven guilty beyond a reasonable doubt?
I'm gonna say yes to that, but I was already, I'm guilty. Yeah, though, because they already said I was guilty.
Look, nobody in that courtroom is bending over backwards for him, but if there is any leniency on the table, it's already in the form of a relatively light deal for a charge that is usually straightforward for prosecutors to prove under Michigan law. Carrying a concealed firearm without a valid exemption is a felony, and instead of recognizing that reality, this defendant keeps digging deeper by trying to talk his way out of it, mentioning things like the gun sticking out or partially visible, but legally, even partial concealment can still meet the definition of concealment, so every extra explanation he gives is not helping his case. It is basically doing the prosecution's job for them, and somehow he still thinks arguing his way through it is the winning strategy.
What you understand is you're giving up certain rights. You have certain constitutional rights. In order to take a plea, you have to give up or waive those rights. That's what
Yeah, though. Yeah.
All right, you understand that you waive your right to be presumed innocent until proven guilty beyond a reasonable doubt?
Yeah.
Is that a yes?
Yes.
Anybody threaten you or force you to get you plead guilty?
No.
Anybody promise you anything beyond what the prosecutors? Anybody promise you anything beyond what the prosecutor's office has offered you to get you plead guilty?
No.
All right. Anybody? Mr. Nature, date, time, location, factual basis, please.
Thank you, Your Honor. Mr. Bailey, on February 5th, 2024, in the area of Binder Street in the city of Detroit.
It's Binder, Binder, Binder.
Binder Street in the city of Detroit. At some point, did you have contact with the police that day? At some point, did you have contact with the police that day?
I ain't had no contact with the police. They contacted me.
Right. Okay. You were arrested that day?
Yeah.
Okay. So prior to that, at some point prior to that, did you have a handgun, a pistol?
You said that I had a handgun, a pistol?
Yeah.
Yeah, I had that big Glocky on me.
And was it concealed in some fashion at some point in a
I had a
pocket?
30 round hanging out the clip. I had a 30 round hanging out. It wasn't concealed. It was a big 30 round on it. It wasn't concealed. But yeah, though, I had it on me.
Okay. Was it in a pocket or under a shirt or something?
No, it was outside. It was sticking out. It was hanging out.
Okay. Was it partially inside of a pocket?
No.
All right.
I had it out.
Mr. Howler, I don't know if you need to have a discussion, but we need to know whether it was concealed or not at some point.
That's what I'm saying. My shit wasn't concealed. That's what I'm saying. I don't even know why I'm going through this. My shit wasn't concealed. It was not concealed.
All right,
Now
Mr.
let's
Howler.
prove it was concealed. And I want to go to trial.
Hold on,
You're
Mr.
what?
Bailey. All right, Mr. Bailey.
My gun wasn't concealed. It wasn't concealed. And I'm sick y'all trying to do me like this.
Alright guys, that wraps up today's courtroom chaos, and honestly this one is hard to believe. There's a real chance we might see more of this case since Judge Saab sometimes streams full trials on YouTube, but if you had to bet on the outcome, it feels like this defendant may have talked himself straight out of probation and into a much harsher result, all because he thought arguing with the court would work better than listening to his lawyer the whole hearing played out.
All right, Mr. Bailey, settle down. All right, Mr. Howler.
Man, this is wrong, man. Y'all do
Mr.
people
Bailey,
like this, man.
Mr. Bailey, just listen. I'm not going to accept the plea. I'll let you go forward to have a trial. Mr. Howler, you want the examination date?
Yes, I do.
All right, so Mr. Bailey, you're going to be going on. I'm not going to accept any pleas from you today, sir. If you're innocent, we're going to let you go forward and exercise your constitutional rights to have a trial. So we're going to the next stage, sir. The next stage is at a preliminary examination. Mr. Najer, as it relates to any offers.
Your Honor, it goes forward as a no reduce plea.
All right. So, Mr. Tooks, can I have examination track for Mr. Bailey?
Not a problem. It's going to be Judge Sabri.
All right, Mr. Howler, this matter is going on the examination track before an Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th at 8:30 a.m. Again, before the Honorable Judge Aaliyah Sabri for a Zoom PCC May 30th, 8:30 a.m.
Okay. All right, thank you.
All right, Mr. Bailey, you going to the next stage, sir. You going forward to have a preliminary examination, sir. You got that date and time?
Yeah, because I ain't going out like that, man. I can't go out like that, man.
That's fine, sir. You can exercise.
I can't go out like that. My shit wasn't concealed, man. They trying to play me dirty.
All right, you can go forward, sir, and have a trial. Have a good day, sir.
Deeper hole with every single sentence while still believing they were somehow ahead. And if you enjoyed this kind of courtroom chaos, make sure to like the video. If not, you already know what to do. Either way, drop your thoughts in the comments and subscribe with notifications on so you don't miss the next courtroom disaster.